one.
Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning. Before we call the first case, just a brief reminder that we don't anticipate any technology-related problems, but if we should have any, everybody will just all take a deep breath and pause while our tech experts correct whatever's wrong, if hopefully they can, and get us back going. Mr. Hivner, if you'll call the case, please.
Leo Charles Hillman et al. Versus Young Street Partners II LLC et al.
We'll hear from the appellant.
Good morning. Please the court. I'm Greg Oakley, and I represent the appellant in this case, Young Street Partners II LLC, whom I will refer to as YSP. And the appellees in this case, Leo Charles and Irene Marie Hillman, I will refer to as the Hillmans. Can everybody hear me?
Yes.
I have tried to make sure that I've turned everything off here that could possibly make a noise, but it's possible that I've missed something. So if that happens, I apologize. But is the court ready?
Yes, sir. Go ahead.
In One Commerce Square LLC versus AUSA Insurance Company, the Western section of this court held that for indemnity purposes, a claim for tenant improvement allowance under a lease does not arise until the tenant has the right to receive payment. In other words, until the payment is actually due. This is the exact issue in this case, and One Commerce Square is thus directly applicable, and its application should result in a reversal of the trial court. In order to prevail in this appeal, the Hillmans must persuade the court that One Commerce Square is distinguishable from or somehow does not apply to the case before the court. They have failed to present any persuasive argument that One Commerce Square is anything but directly on point. And the trial court's attempt to distinguish One Commerce Square, which is different from the Hillmans' argument, fails as well. Now, so briefly, in One Commerce Square, just like in this case, there was the sale of a commercial building that had tenants with leases. There was an assignment and assumption agreement, just like in this case, with seller indemnity language that is extremely similar, and we say functionally equivalent to the indemnity language for the seller in this case. In One Commerce Square, the work was fully completed in 1995. Invoice submitted, payment requested, but under the lease in One Commerce Square, the payments were to be made twice, or two payments. The first one was in 1995. The second one wasn't due until March 1st, 2000. And the closing of the sale of the building occurred, I believe, in 1999. In any event, it was before March 1st, 2000. And so a dispute then arose between the buyer and the seller regarding who's responsible for making this second payment. And this court,
in the case that you're referring to, wasn't there a date certain for the payment?
There was, Your Honor. There was a date certain.
In your case, is there a date certain in your agreement?
Yes, there is, Your Honor. There's not a like in One Commerce Square, it was just March 1st, 2000. Okay, so that was the date. In the lease, the ADP lease in our case, there's a date certain, but you don't know what that date is until the conditions precedent to payment have been satisfied. But the date certain is 30 days after the conditions precedent to payment have been satisfied. So even though it doesn't say March 1st, 2018 or something like that, there is a date certain. It's just that it's the certainty of the date will not be established until the conditions precedent are satisfied. Okay. So in One Commerce Square, the Court of Appeals held that because the tenant did not have a right to payment, because the landlord did not have the obligation to pay until March 1st, 2000, after the closing, the claim for the second payment of the tenant improvement allowance did not arise until after the closing, was not covered by the seller's indemnity and was the responsibility of the buyer. And we had the exact situation in this case where the payment was not due until after the closing, regardless of when ADP asked for it. It wasn't due until after the closing. And so the claim for that payment did not arise until after the closing, and the indemnity provision does not apply. The seller indemnity provision does not apply to that payment. Now, the Hillmans recognize, of course, that they have to distinguish One Commerce Square. And so their argument, which the same argument they made in the trial court, they make it in this court. And what they did was they looked at the indemnity language in One Commerce Square, compared it to the indemnity language in our case, and said, well, the indemnity language in One Commerce Square includes obligations, and that's not included in ours. And so that makes the cases different. And specifically what they say is that the One Commerce Square court was analyzing the lease in that case to determine whether both the claim and the obligation, which the Hillmans contend are two different things, arose prior to the closing. And what One Commerce Square held was that the obligation arose after the closing, but it didn't hold that the claim arose after the closing. Now, there's no analysis of any kind by the court in One Commerce Square regarding a claim and an obligation. Nowhere in that opinion did they say, well, we have to decide whether both the claim and the obligation arose prior to the closing. And we find that the claim arose prior to the closing, but the obligation arose after the closing. That's just nowhere in that opinion. And more importantly, there's no way to interpret the indemnity language in the One Commerce Square seller indemnity to comport with the Hillman's argument, because this is the language that in One Commerce Square that is at issue. It says, assignor shall defend, indemnify, and hold harmless assignee from such claims or losses incurred by assignee arising prior to the effective date hereof, and as a result of assignor's obligations under the existing leases. Okay, so what that language says clearly is that there are two things that must be present with respect to claims before they are subject to the indemnity. One is the claim has to have arisen prior to the closing. The second is that the claim has to be related to an obligation under the existing leases. So,
counsel, with respect to the amendment to the office lease in paragraph 3, the tenant improvements, as I understand, before the closing, there was presented to your client an email demand for payment with an invoice and certain lien waivers. Is that correct?
that is correct, Your Honor.
And so the language,
2 days before closing.
the language under the paragraph 3 tenant improvements, as we know, provides shall reimburse within 30 days of presentation of an invoice showing the amounts owed, and if appropriate, lien waivers, and then the permit. What does if appropriate mean?
Well, Your Honor, that's not spelled out exactly in the contract. But as the court knows, of course, when interpreting a contract, the court needs to consider the intent of the parties, consider the contract as a whole. And the only way that the if appropriate and if applicable language that relates to the liens and the use and occupancy permit, along with the and/or, is that in some cases, lien waivers are not going to be appropriate because you don't use a contractor. A tenant can make improvements themselves. They don't have to use a contractor. If they don't use a contractor, they don't need a lien waiver. Also, there are, and this is all set forth in detail in our brief, but there are a number of types of maintenance and repairs that one can make to a commercial building in Metro Nashville, for example, that do not require a use and occupancy permit and don't require all the other permits that lead up to a use and occupancy permit. So like, for example, if you're just changing out the carpet, under the terms of this lease, ADP could have decided to change out the carpet and they could have decided to do it themselves. Maybe they have somebody in-house. A lot of companies have in-house maintenance and in-house building people, so they don't use contractors for things like this. But so, for example, if ADP had decided that they were going to change out the carpet and paint the office, they would be entitled to reimbursement for that cost from the landlord, but they would not have required any lien waivers, and they also would not have required a use and occupancy permit. Okay. Now, on the other hand, if they use contractors to change the carpet and to do the painting, they would need a lien waiver, but they wouldn't need a use and occupancy permit. And so there are situations where lien waivers are appropriate because you use contractors. And there are situations where a use and occupancy permit is applicable because you have to have one. Okay. And so what the court has to consider is why do these conditions preceding to payment exist? Why are they there?
Counsel,
They're there. Yes,
counsel,
yes, sir. Yes.
I'm sorry, before you run out of time, of the two things you said that are required there, what do you say is missing here?
Both of them.
And the claim did not arise before the closing date.
That's correct.
You're saying why didn't it arise before the closing date? Because
the payment was not due. Because
the payment had to be made by no later than a certain date.
No later than 30 days.
Now, does that mean that the payment wasn't due?
Yes, Your Honor. The payment is not due until 30 days after the lien waiver. All of the lien waivers from all the contractors are presented to the landlord, and the use and occupancy permit is presented to the landlord.
I understand what you're saying, but is that what it says? It says it's got to be paid within 30 days.
Within 30 days of presentation of an invoice, and if appropriate, lien waivers, or if applicable, a use and occupancy permit. So, and this goes back to what I was just talking about. The reason these conditions preceding are there is to protect the landlord, because I
understand your argument on that. I'm trying to figure out though why, when the invoice was sent and received before closing.
Yes, Your Honor.
Why it didn't arise then, and you say because your client had until 30 days after that to pay.
No, Your Honor. That's not what I'm saying. No, what I'm saying is that my client had 30 days after he was presented with an invoice, a demand for payment, the lien waivers, and the use and occupancy permit. Those are all required by the express language of the lease.
And what didn't your client get 2 days before?
My client only got 1 out of 5 final lien waivers, only got 1, and the use and occupancy permit had not even been obtained. So it wasn't the final, most of the final inspections, the plumbing, the low voltage, the electrical, none of that had even happened prior to the closing. And so they couldn't get a use and occupancy permit. The use and occupancy permit was not even obtained until weeks after the closing. My client never got that. My client never saw all of the final lien waivers until this lawsuit was filed. And so, and Your Honor, to answer your question, I can quote the trial court, because the trial court said in a footnote, if I can find it, that okay, so after the closing, weeks after the closing, the use and occupancy permit is obtained and presented to the Hillmans. The final lien waivers are presented to the Hillmans. The Hillmans pay the $92,000. And what the trial court says is that it's clear from the record that prior to the trust, that's the Hillmans, prior to the trust payment to ADP of the $92,000 allowance, an invoice and all final lien waivers, as well as the use and occupancy permit, were obtained. Thus, paragraph 3 of the lease has been satisfied and payment was required. So the trial court itself recognized that all of those things were required before the 30-day period started. and payment was required.
All right, Ken, thank you. You have your time for rebuttal. We'll hear from the appellee.
Morning, Your Honors. Matthew
morning.
Murphy on behalf of the Hillmans. And just as Mr. Oakley did, I'll refer to the seller here as YSP, and the tenant improvement allowance I'll refer to as TIA, just for the sake of brevity. Your Honor, what's at issue here is, Your Honors, what is at issue is this assignment agreement, and the assignment agreement is unlimited. There's no question about that. The assignment agreement says that the assigner agrees to indemnify, defend, protect, and hold assignee harmless from and against any and all claims, including a reasonable attorney's fees, arising out of or in connection with the lease for the period prior to and including the date hereof. The distinguishing factor that Mr. Oakley is looking for between this case and One Commerce Square is the indemnity clause itself. The one in One Commerce Square is conditioned. And Mr. Oakley even walked through those conditions. In that case, the indemnity clause was for such claims or losses incurred by assignee and as a result of assigner's obligations under the lease. So you need the claim to happen and you need an obligation to happen. They are two separate things. If there's a tort claim that's filed, a lawsuit that's filed, that's a claim for damages. Not every claim is an obligation. If there's a determination made that an injury didn't happen or the damages didn't occur, there's no obligation by the defendant to pay damages to the plaintiff. So in One Commerce, there has to be not only the claim, but there has to be an obligation as well. And that's missing from the assignment in this case. It's unlimited. The assignment doesn't differentiate between valid or frivolous claims, doesn't differentiate between timely or untimely claims, and it doesn't limit the type of claims for which YSP agreed to indemnify the trust. And that's what's trying to be done here by YSP. And so from the Hillman standpoint, the claim was made as soon as that demand for payment by ADP was made. That's a claim. It then becomes the obligation of YSP to indemnify the Hillmans and hold them harmless for that. The analysis can stop right there. Now, I believe that regardless of whether or not the court determines that that's sufficient, the Hillmans were entitled to payment under the lease as well. The conditions precedent that Mr. Oakley is talking about were met. Because in order to get payment under the tenant improvement allowance, all that needed to happen was that the seller would be presented by invoices, and then by lien waivers and or a use and occupancy certificate. The problem that YSP faces is that it finds and or to be an ambiguous term on its face, whereas and or has a clearly defined meaning. You can find it in the dictionary. You can find it in the law review articles cited in our brief. And or means A or B or both. That's it. And so under the lease, the tenant was entitled to be paid for the tenant improvement allowances once the invoice was presented, the lien waivers, or the certificate of occupancy, or both, A or B or both. And Mr. Oakley attempts to have the court nullify the terms that was contracted between the parties. The parties used and or specifically. If the parties wanted to say that both the lien waivers and the use and occupancy certificates were required, they would have said and, but they didn't. It says and or, and that's the agreement between the parties. It's not ambiguous. It doesn't lead to a latent ambiguity that cannot be resolved by reading the contract. It's very clear. Invoice, waivers, or use of occupancy certificates, or both. And so under that construction, as soon as YSP was presented with the invoice and the lien waivers, that claim was due. That demand was due to be paid at that time. It was due to be paid within 30 days. And so what Mr. Oakley is attempting to do is shift that 30 days out, saying, no, it's not due until the expiration of that 30 days. The issue was that ADP, the tenant, was entitled to payment the day that those things were presented. It was due. They were entitled to be paid. That was when the claim was due. This would be no different than if a borrower mailed a payment to the lender and the lender sat on the check, didn't deposit the check, and said, oh no, your payment is late. You haven't met the requirements under the lease. And that's what YSP is trying to do here. They had all the information available to them. They had the invoice, they had the lien waivers, and didn't take any action and attempted to pass this obligation off on the Hillmans, who were told up until the day of closing that this was all going to get paid anyway. Your Honors, this gets back to the if appropriate and if applicable language that was being questioned earlier. Under the lease, the if applicable and if appropriate language, that's in the sole discretion of the landlord in this case. It's not clearly defined. And so if the landlord determines, well, those things aren't applicable, then those don't need to be presented in order for payment to be received. But there was never any action taken by YSP to say, hey, wait a second, we don't have all the information. These things haven't been met. There's an obligation for YSP to deal with this claim as it's made. That's the whole point of the indemnity agreement, is to make sure that they're taking action to resolve claims prior to the sale of this property. Your Honor, Your Honors, I don't believe that there's any issues here that aren't clearly defined within these two contracts. The assignment agreement is clear and unambiguous. It makes it clear that the seller is obligated to defend any and all claims. Okay, YSP is asking that the court insert conditional language into that assignment that does not exist. Then YSP is asking, once that language in the assignment agreement has been changed, now we're going to change the lease terms as well to require there to be additional information or additional conditions that weren't there. Nowhere, the lease does not say and. It does not say that the lien waivers and the use and occupancy certificates must be presented. It says and or, which is A or B or both. There's also been a lot of discussion by YSP that these need to be final lien waivers in order for this to be effective. The word final does not appear anywhere within the lease. It says lien waivers. YSP had lien waivers in hand days before the closing. So what's happening here is YSP is not happy with the results and the contract that they drafted and signed, and are now trying to add additional words and conditions in there to protect its interests. And Your Honors, I don't think there's any question that both of these agreements are clear and unambiguous. There's no need for the court to step in and define terms that don't exist, or add or remove terms that aren't present, that were bargained for between the parties. And I believe that the ruling of the trial court should be affirmed, and that this matter should be remanded for award of additional attorney's fees under the indemnity clause to the trial court for the additional expenses of having to go through this appeal. Your Honors, if you have any further questions, I'd be happy to answer them.
I hear none. Thank you. Well, we'll hear from the appellate rebuttal.
Your Honors, first, YSP did not receive the lien waivers from all of the contractors who worked on the project. I would invite the court to look at the record. There were four final, what they were presented with were one final lien waiver, 4 preliminary lien waivers that were done midway through the project. And there was work that was done after those conditional lien waivers or preliminary lien waivers were submitted. So it certainly was not undisputed, and this is a summary judgment case, that YSP actually received the lien waivers from all of the contractors. Second, Your Honor, with respect to the use of and/or, I understand Mr. Murphy's desire to use the dictionary definition of and/or, but we have courts for things like this. And what the courts in this state have said, specifically in Victory versus Victory, which is cited in my brief, is that it is said, regardless of how courts and legal writers feel about the term and or, it is fairly clear that where the term is used in a contract, the intention is that the one word or the other may be taken accordingly as the one or other will best affect the purpose of the parties as gathered from the contract taken as a whole. So what this court has said, if it's and/or, it can be and, or it can be or. The court has to look at the purpose of the contract, the intent of the parties to determine which one it is. And in this case, the only way to reconcile and/or and be consistent with the intent of the parties is that it's and if lien waivers are appropriate, it's and if you're required to have a use and occupancy permit for whatever work you have done on the building. If not, then all you need is lien waivers. Mr. Murphy stated that claims and obligations are two different things, and not every claim is an obligation. That's if we take that to its logical conclusion, Your Honor. What did YSP indemnify in this case? Because YSP didn't indemnify against obligations. It only indemnified against claims. So if claims and obligations are two different things, and if 1 comma square, as the Hillmans argue, only stands for the proposition that obligations arise when the payment is due, but not claims, then what did YSP did not indemnify the Hillmans against any obligation. And without an obligation, what is a claim worth anyway? So according to Mr. Murphy, what YSP did was indemnify the Hillmans against the claim that was made on December 11th, 2018, which did not have the conditions precedent to payment being satisfied. So if YSP is required to indemnify against that claim, okay, that doesn't mean anything because that claim doesn't have an obligation. And so it has no value. The only thing that matters is the obligation. And it's very important that in paragraph 2 of this assignment and assumption agreement, the Hillmans, the buyer, agreed to perform all obligations of the leases that arise after the closing. So under their position, the Hillmans have agreed to pay this obligation if the right to payment didn't arise until after the closing. Thank you very much, Your Honors.
The court thanks to counsel for both sides. We appreciate your briefs and your oral argument on this. Mr. Hillman, if you'll recess court until our next scheduled case.
This honorable court is now in recess until 10 a.m.
Thank you, counsel.